with a focus on DeFi in the last couple years.
Hi, my name's Rebecca Rettig. I'm also a partner at Manatt, Phelps & Phillips. I do litigation and enforcement work as well as regulatory counseling. I also focus pretty heavily on blockchain and crypto clients and have been doing that really for the majority of my time over the last 4 years. And like Marc and with Marc, I've been concentrating on DeFi for the last 18 months or so.
Great. And then Colleen, can you do a quick intro? There we go.
Yeah, and I apologize for the background. I had to get to a place with better Wi-Fi with the kids all doing remote learning. But Colleen Sullivan, CEO, co-founder of CMT Digital.
Great. All right, so let's jump in with a little bit of background for folks who didn't pay extremely close attention like we did to all the details of the Bitmex actions. So for those who don't know, Bitmex is a cryptocurrency derivatives exchange. It has billions of dollars worth of trading per day. It's most famous, I think, for pioneering the Bitcoin perpetual swap instrument. According to the government's allegations last week, since November of 2014, Bitmex was offering crypto derivatives to US persons without registering with the CFTC or establishing an anti-money laundering compliance program, as they allege is required by US law. So last week, Bitmex and its co-founders were hit with 2 separate enforcement actions, a civil case filed by the CFTC and a criminal prosecution by the Department of Justice. I want to start with Marc to set the stage a bit here. So the charges, Marc, stem from those 2 separate regulatory frameworks, the Commodity Exchange Act and the Bank Secrecy Act. Can you just tell us a bit more about the allegations and the nature of those charges?
Sure, and they go to kind of the core of what the Commodities Exchange Act requires, as well as the regulations from the CFTC when you are in the space, and specifically when you're dealing in derivatives. And to frame that, let's use kind of the term, whether it's futures, options, swaps, or if you're talking about retail commodity transactions that are leveraged, kind of any of those will fall in that bucket. And so the issue here with Bitmex was that they were offering, as well as kind of confirming the execution of, off-exchange options as well as futures. When you're trading in any of those, that should be done on an exchange with certain kind of limited exceptions to that, and that kind of goes into the second part of it, which is that Bitmex wasn't registered as an exchange, and specifically that's as a designated contract market. And given that it was a trading facility and operating a trading facility, the allegation was that they were operating that trading facility without having been registered as a designated contract market. Somewhat similarly, because they often go hand in hand, they also did not register as a futures commission merchant. And so, the important thing there being, if you are going to solicit or accept offers in derivatives, then you need to be registered as a futures commissions merchant. And to be more specific, that would be in situations where you're actually going to be holding any kind of property or money, and that could include crypto specifically, could also include just fiat. So those are kind of the, I'll call them kind of core CEA, Commodities Exchange Act claims. There was also kind of failure to supervise agents under the CFTC regulations, as well as something that goes hand in hand and is very important for kind of both cases, is that, when you are an FCM, you also have the obligation to comply with the Bank Secrecy Act. And the reason for that is you're considered to be a financial institution, and financial institutions have the obligation to comply with the Bank Secrecy Act. And that brings us to the indictment, which really is focused on the Bank Secrecy Act. The first part of it is simply a violation of the Bank Secrecy Act. And importantly, laid out pretty clearly that these violations were willful. And if you walk through it, there's kind of core knowledge of what needed to be done to be registered as an FCM, but more importantly, in this case, to put in place a AML and KYC kind of compliance program and file suspicious activity reports when necessary, and then do that. And then the second part of it is a conspiracy to violate the Bank Secrecies Act, and the idea there is that there was willful and kind of knowing kind of coordination to go ahead and violate that, and they lay out again over several pages, everything that the Bitmex founders were doing to violate the Bank Secrecy Act.
Awesome. Thanks for the summary. And I think one thing that's really noteworthy about this case is it isn't just a civil enforcement action, right? And we've seen the CFTC launch civil enforcement actions against other derivatives exchanges like Bitfinex, for example, a few years ago. But what's interesting here is that this also became a criminal case of DOJ getting involved. So Rebecca, I'm curious for your thoughts on why this became a criminal case unlike those others and why that's significant.
I think it's significant just to go off of the sort of tail end of what Marc said, which is if you're an FCM and a financial institution and you engage in willful conduct to violate the Bank Secrecy Act, that carries with it criminal penalties under the BSA itself. And I think that the conduct, when you read the indictment, was so egregious, both from a conspiracy perspective and from a knowing and willful perspective to violate the Bank Secrecy Act, to ensure that there was no KYC AML, and quite frankly, to engage with individuals who were living in or had citizenship for OFAC sanctioned countries, that there was no way that they could turn their back on this kind of criminal conduct. For something like Bitfinex, first of all, that was really early. That was 5 years ago, maybe. And I think there wasn't the same level of knowing and willful conduct, at least not that we know about, and certainly not enough to bring it up to the criminal level. But I think when you read the indictment, it certainly reads like there was at least allegedly criminal conduct here that rose to the level of bringing an indictment. And I'll say for something like this, especially first time out of the gate crypto, and for something like violations of the BSA, you can assume that they at least have really good evidence to have really gone forward with this indictment.
Yeah, and another difference with Bitfinex is Bitfinex ended up being a negotiated settlement in which they got cooperation credit, right? And the CFTC even said that during the investigation, Bitfinex had made all kinds of changes to their platform at the request of regulators. So it seems like whatever negotiation there was here must have broken down. We should mention that, of course, all of these are allegations. We've only heard one side of the story. Bitmex and its founders, like always, are innocent until proven guilty. So, we'll sort of take the allegations for what they are. Let's jump into talking about what this all means for DeFi, which is really what brings us together for this panel. I think the big question on everyone's mind is whether a DeFi protocol is subject to the same regulations as a centralized exchange like Bitmex. And I think first it's important to explain how DeFi protocols are similar and also how they're different from centralized exchanges. So Jason, I want to bring you in for this. Can you tell us a little bit about how DeFi protocols are different or how they're the same to centralized exchanges?
Yeah, so I think there's kind of two ways to look at this. One is from a user's perspective, right? So with a centralized exchange, what you're doing is kind of establishing a relationship with a third-party company, right? So in the situation with Bitmex, these users are signing up for those services, sending their money to that company, and a lot of the activity that occurs for trading is occurring kind of within that company's databases and within the confines of what it controls. With a DeFi protocol, the unique element is really what the user is doing to some extent is interacting directly with the blockchain. And so in that capacity, you're not necessarily handing over custody of your crypto assets to a third party. What you're doing is kind of entrusting them to the rules of the blockchain as written by these DeFi protocols. And so there's kind of an element of a lack of custody by a third party that is kind of key to when users are using DeFi protocols. On the other side of that coin is kind of, well, who controls these protocols? And I think there's a kind of wide spectrum that can be implemented. In some ways, you can have, something that is, I mean, inherently all of these protocols are running on a blockchain, right? So they're being run by multiple nodes in the Ethereum world. But you could have something that is a DeFi protocol that is, still technically kind of can be controlled by a third party company, right? Whoever kind of has the authority to make changes to that protocol. There are other protocols that have been launched that kind of eliminate that ability to even control them, such that they really are just kind of tools that exist on the blockchain that these users are interacting with. And then I think there's, a middle ground where we've obviously seen worlds in which DeFi protocols have been created with some level of control distributed to either token holders or a group of people who can make changes. And so there's, from the user's element, a lot of this can look the same, right? The nature of the trading that you're doing. But ultimately, the key there is kind of not losing custody of your assets and directly interacting with the blockchain. And on the flip side, there is the issue of like, well, who controls what is happening with this money once it's deployed to these systems? And as opposed to, necessarily a company in the centralized exchange world, you have a situation where it can be varied, and it could be no one, or it could be a wide group of people.
Right. And, I think there's sort of two ends of the spectrum in thinking about how decentralization relates to regulation, right? There's some lawyers who will say, all of this is the same and all the same regulations apply. And then there are some people who probably aren't lawyers who will say, it's on a blockchain, no regulations apply at all. And so, before we dive into sort of the details of the CEA and the BSA, Colleen, I'm curious for your sort of big picture thoughts. How should we think about the relationship between decentralization and regulation?
Yeah, and I'll pick up on some of what Jason was just saying. We've named this industry decentralized finance, but the reality is there's degrees of decentralization, and it takes time to achieve what I think many of us would consider full decentralization, which I would define as the project not being controlled or reasonably likely to be controlled or unilaterally changed by a single person, a group of persons or entities under common control, and where none of those persons are necessarily benefiting financially from the operation of the protocol in a disproportionate way. So that's a mouthful, right? So here's how I would break this down in light of Bitmex. And really with respect to the three bodies of law that I think are most prominent, and that there are many others that we're not, I think, going to get into today, but really that's the BSA, securities laws, commodities laws. And I think if you start with FinCEN and the Bank Secrecy Act, as Jason noted, Bitmex was clearly a centralized crypto exchange. There was nothing about it that was decentralized or attempted to be decentralized. So as Jason said, with DeFi, you essentially have software that is enabling a decentralized exchange that does not have custody over the crypto assets, and it's matching people who are going to settle those trades peer-to-peer. So the types of BSA rules and regulations that applied to Bitmex really should not apply in the context of decentralized exchanges. And FinCEN's May 2019 guidance is helpful in that context. That doesn't mean, however, that people who use the software are not regulated, in some way where they have to be mindful of how they're using, that protocol. And then to answer your question, does decentralization or not having custody in the context of FinCEN, is that an absolute defense? And the answer is definitely a clear no. So if there's bad activity occurring on a platform that gets to a relatively egregious level, Treasury, they've got other tools that they can use, including conspiracy to violate the BSA. There's also OFAC, which isn't bound by the May 2019 guidance. So if, we start having big nightmares in DeFi where you've got, for example, significant participation from OFAC digital currency addresses associated with sanctioned persons, the government's going to find a way to do something. I think it's also important to keep in mind that FinCEN BSA analysis, which draws reasonably clear lines for DeFi projects, does not apply with respect to US securities and commodities laws, where the guidance or the laws and rules are softer. And that's intentional in the sense that, as we saw with Bitmex, there are criminal, penalties associated with violations of those laws. It's not, quite the case with securities and commodities. So if you start with the securities laws, I think a project has to consider whether any token associated with the platform, governance, protocol token or other is a security, which everybody knows plenty about with Howie. But germane to this issue, I think that the industry has to look at the SEC's enforcement action against Zach Coburn, the founder of ETHDelta. That would be instructive, and I would encourage everybody to read that. But the takeaway should be that the SEC looked past the label of decentralized exchange to identify a party that they thought had control over the protocol and therefore regulatory responsibility. So I think the question for us is, do decentralized exchanges, are there facts that are differentiated from ETHDelta, like no admin key or backdoor, a widely distributed governance token that's not a security, no controlling group hosting the website, allowing participants to interact with the smart contracts, no order book, use of an AMM, no control of the assets being listed on the exchange. With respect to commodities laws, I think the Bitmex case, if nothing else, shows the tremendous global reach of the US commodities laws. And so as Marc had noted, if a DeFi project is dealing with derivatives on any commodities, and let's all keep in mind that commodity is about the most broadly defined word you can have, only excluding onions and motion picture box office receipts. And then of course, securities fall under the purview of the SEC. But you've got to think there, does the project need to exclude US addresses? Is that sufficient? And similar to the issues I was just talking about, is the project sufficiently decentralized so that from a practical standpoint, there is no one to go after? I guess I would also say, just from a very practical standpoint, and then I'm going to stop talking, each of the regulators that I just mentioned, has some form of a lab or open door policy where they invite innovators to come in and talk with them about the projects. And there's definitely a step in the right direction, considering we don't have, regulatory sandboxes in the United States. But at the same time, projects will often say, well, I don't want to go in. I don't want to be on their radar. So from a practical standpoint, sometimes that doesn't always work. And we also see teams leaving the United States because they want to go to jurisdictions where they feel like the rules of the road are more clear, or there is a bespoke regulatory regime. I think, though, if you look at the enforcement actions in our industry to date, the regulators have generally taken a kinder, gentler hand to projects that tried to comply. And from that, what I take is there is actually something, and Jake and Jason are both leading this up on behalf of the CDA, that the industry can do today. And I think that is self-regulation. And when I say that, I don't mean, going to Congress and trying to get authorization to be the next FINRA or NFA. I mean, maybe that happens at some point in the future. But really all I mean is the DeFi industry coming together to establish best practices, policies, and procedures for how they want to operate in this space. And I think Commissioner Peirce in her safe harbor proposal gave us a roadmap to what kind of disclosures DeFi projects can provide. And that's something that can happen today. And then, I also think that the industry needs to think about best practices around smart contract audits, insurance, if or how you want to screen for OFAC and other sanctioned wallet addresses. Do you want to provide any assistance with reading smart contract code or calling out certain things that people should look for? And then I also think it's important to devise systems to track and quantify risk. Are there certain protocols that you may not want to interact with because they don't have, prudent procedures around collateralization? Lastly, I think the industry has to spend some time thinking about if it wants to build bridges into centralized crypto and traditional finance. And to a certain extent, that's happened with something like USDC. But if you are going to tokenize real world assets and bring them into DeFi, do you necessarily bring the regulatory regimes that those assets are subject to into DeFi? And if you want large regulated institutions that are fiduciaries of third-party capital participating on your platform, do you need permission pools where certain participants have gone through KYC and AML? So there's just some practical considerations too, in terms of how much does DeFi want to scale and who does DeFi want to participate? So I'll leave it at that.
Awesome. Yeah, no, you made a bunch of really great points, and I want to unpack basically all of that. I want to start though with a really great point you made about identifying specific regulatory frameworks and then distinguishing between the protocol that lives on a blockchain versus the actual actors, right? The people who have developed the protocol, the people who are creating access to the protocol, the people who are using the protocol, and asking better questions than what we often get as lawyers, which is DeFi regulated? And that's just a bad question, right? If you ask bad questions, you're going to get bad answers. The good question is, what regulatory framework might apply and to whom? And then to look at the specific facts and circumstances to decide whether the regulation should or shouldn't apply. And then, like you said, think about the discretion that regulators have in thinking about, what action they actually want to take. So I want to open this up now to the whole group and ask, when we think about regulation in DeFi, who is the right subject of regulation? Is it the code itself, or is it somebody else who's sort of using the code or working in the space? Who is the right subject for regulation?
I'll jump in just to start, but obviously this is a pretty deep question. I'm sure everybody has a different take on it, but I think you have to look at it from a number of different angles. And you also have to, the first thing you have to do is look where the project is in its life cycle, right? If you're starting from the beginning, where the code is just being written and the protocol is pre-deployment, you have a pretty centralized group in place who's writing the code and about to deploy it. So you definitely have to, look at where you are. If you're further along the spectrum of decentralization, that may change the analysis in itself. So to the point you made, you do have to look at the group who is at least behind building the protocol. You have to look to see their level of continued involvement in the protocol itself. And you have to look to obviously understand whether there's a governance system in place that's continuing to build the protocol. The other thing you have to look at is whether, and you sort of alluded to this and Colleen did too, whether the original group or some other group is facilitating access to the protocol, because something like a user interface obviously brings along with it its own implications under these regulatory regimes. And so you have to break that out as well. So and finally, then you have to think about who's using the protocol, like you talked about, because there's this concept here where, fine, maybe there's liability for developing a protocol that violates one of these regulatory regimes, maybe for even hosting an interface that allows violations of these specific regulatory regimes. But the other thing is, if you are allowing or have created a protocol that allows others to violate laws and regulations, you may be what's called secondarily liable. People may think of it as like an aiding and abetting type of claim, just more in common parlance. But you can be secondarily liable under a lot of these regulatory regimes, and especially under the securities laws and the commodities laws. So you have to be thinking about that as well.
Yeah, and I think what I'd add is maybe even before looking at who it is that's regulated, maybe the question is, and not to be that guy who says nobody's regulated, because that's not at all the intent, but you do have to look at, like, is there somebody who should actually be regulated in this context? And I think that when you look at the purpose behind some of these laws, and this has been laid out by, at least, Director Hindman, in terms of kind of looking at whether anyone should have disclosure obligations. I mean, you start looking at, is there a purpose in applying these laws? So I think that's like a first step. Once the answer is yes, then the question is, well, then who do you apply it to? And I think there's generally one group, which is, any kind of intermediary, with the one exception that I can think of off the top of my head, being in the commodities law context, and that is off-exchange transactions and derivatives that need to be between eligible contract participants. And those participants have an obligation to ensure that's the case as well, even if there's no intermediary in that transaction. But leaving that aside, you really look at, is there an intermediary? And I think Jason and Colleen both put it extremely well in terms of kind of the different decentralized levels of decentralization that exist. And I think in certain situations, the answer is going to be, these people might not view themselves as intermediaries, but they have enough control, enough impact, there's enough concerns in terms of what they can do or what they are doing, that they should be treated as intermediaries. And if that's the case, then they should be regulated as such, regardless of the regulatory regime that applies. And I think that's commodities laws, just as much in terms of being a trading facility and therefore being registered as a, designated contract market, or, whether you're looking at the the BSA, and you should be treated as a financial institution that has the obligation to implement a KYC and AML program. I think that's my take on it.
Yeah, just one last little thing to add on to that is whatever you call your protocol or your project is not enough to escape you from regulation. So if you call your protocol peer-to-peer, but the facts and circumstances around it show that there's an intermediary or you have control over it and it's not quite peer-to-peer, the name itself is not enough to get you out of being regulated.
Yeah, to build up that concept, I mean, one framing I think I bring when I'm trying to think about this is like, if you imagine Bitcoin as a single node system, right? It would be regulated as like a money transmitter, right? Because it would just be a centralized database where some person is helping you kind of facilitate transfers of value between two people. It's strange in the sense that when you distribute that power amongst a bunch of people, we start to view the system as something different, right? And so I think to your original question, Jake, it's like, there's kind of a reason we don't want to regulate the technology. We want to regulate the people, because the technology can be implemented in a bunch of different ways. And really what matters is kind of how are people implementing that? How are people using that? And to kind of build off some of the points that Marc and Rebecca were saying, I think there is questions when we talk about regulation. So if we take Bitmex, and just bring that into DeFi, right? There is a world in which at its base, it is not illegal to create a system that helps people trade what look like derivatives, right? There are countries where that can be legal. There's regulatory regimes where that works, right? And so at the heart, building a technology that allows that shouldn't be considered illegal. And there's a lot of also like constitutional arguments in favor of that. The difficult part comes when there's additional layers of control or intermediaries involved in that process, or people soliciting users to that. Then it becomes more likely that you're taking on activity that the regulations would say, hey, we're not saying you can't build this technology. We're saying you can't go to US users and invite them to be retail traders in derivatives on this platform. And then I think, so that is a question of control, decentralization, and all of the questions that become very difficult to apply, honestly, but like these are the kind of things we have to wrestle with of, do we regulate an intermediary in a blockchain world? The last part I would add is, I think there is an interesting question that's raised by all of this about, do we regulate the users? So in the CFTC context, there was a speech a couple years ago from one of the commissioners kind of talking about the struggles of potentially regulating something like a smart contract protocol that facilitates derivatives. And kind of one of the throwaway lines in there was like, well, we're never going to regulate the users, so maybe we want to regulate at this part of the stack. And I think one of the interesting questions that's presented by all of this is like, our laws currently say like, you as a retail person cannot get involved in derivatives absent some very restrictive, means of getting there. And that might be a good thing, but it's also a difficult one for people to understand for, hey, why does big company X or rich person Y get access to this market that I don't? And you're kind of seeing that even in the traditional financial world of things like Robinhood, where people are going there to trade options and the like. I don't know what the right answer is, but I'm just saying there is a world in which we have to look at the regulations as ultimately applying to the end users. And is that somewhere where we want to be? Do we need to do more on that? Do we need to change the laws on that front?
Yeah, it's a really good point. I think usually when we talk in the crypto industry about DeFi regulation, we're focusing on the developers of the protocols or the folks who are creating interfaces so that users can access the protocols. We spend a lot less time thinking and talking about how the regulations might actually apply to the users and whether those regulations make sense in this context. But I guess just to dig in a little bit more detail, to one of the first points you made, Jason, about, if Bitcoin was a single node and was fully centralized, there wouldn't be any good argument, I don't think, to say it's not a money transmitter. And similarly, in the Bitmex case, the main trigger for this action was that Bitmex was a centralized player performing the services of a futures commission merchant, that is accepting and soliciting orders for derivatives while also accepting money used for the purpose of trading those derivatives. I guess then the question is, in a decentralized system, so in, let's say, an options protocol in the DeFi world, of which there are a few, is there any chance that that type of protocol could result in designation as a futures commission merchant or some other designation under the Commodity Exchange Act? How do we think about how the CEA applies to derivatives in DeFi?
I think, like, just to build off one of the points I was making, I wouldn't so much see it as like the protocol is regulated, right? I think there is a question of what are the actors in this system doing, right? And I think one of the really hard questions that I don't know the answer to is ultimately, if you assume there is a world in which this protocol can exist on Ethereum, you know, and that is a legal act, then really what the equivalent of being an FCM in the DeFi world would be is running a website that allows a user or invites users or, you know, profits off users coming in and using that protocol in order to trade, you know, what regulators would call derivatives. And so then you get into a world where it's like, are we going to regulate the front end website companies, right? And I guess there is then a distinction between, are you just running a website or are you running a company, you know, through that website, as in terms of charging fees or whatever. And I think in that environment, the answer is like, you know, a broad interpretation of the US law is yes, like if you are operating a front end website that is inviting US users to trade derivatives and you're running that as, you know, part of some kind of for-profit entity, like that is within the confines of what we would say, like, you know, just if you strip away all the technology, which is one of the ways I think about this, right? You know, you can imagine there's a way to peer-to-peer trade derivatives between people by, you know, doing contracts and the like, right? If you host like a nice, you know, storefront where you say, hey, come inside and, you know, trade peer-to-peer with these people, like, I'm pretty sure that's going to trigger the law too. And so I would move it away from like, what is the protocol doing, and more, what are the actors who are trying to build businesses, right, on top of it doing?
Yeah, I think that's a good point. I mean, I always, you know, my starting point is always like, okay, let's look at a protocol where the only thing that you've done is write code, and that's it. And then you've realized that you have nothing else to do. Does the regulatory regime apply in that situation, right? And in the context of the CEA, you know, the answer is going to be there actually technically is some kind of well, actually, depending on how the protocol is built, there might be some kind of acceptance of orders, right? But then the question is like, who is accepting it? But the bottom line is, unless you get into those technical arguments in terms of like just wording under the CEA in terms of like hyper technical, like should this apply based on the words, in which case, frankly, there's always going to be some kind of hook there, and you're not going to have any level of clarity. And you know that the CFTC, I think in the same speech that you referred to, Jason, a couple years ago, you know, basically said something along the lines of, you know, if a software developer is developing a, you know, protocol for the, you know, trading of derivatives, we're probably going to look at that software developer for having done that. And the reason is, you can almost distinguish option protocols from others, right? You can create a protocol that is neutral in the way that, similar to the way you were describing earlier, Jason, but you can also create one, I think, where you basically say, here is the sole purpose of this protocol. And I think that there's probably a basis for distinguishing between those two based on kind of the intent of what you're trying to do. And so I think that part ends up being pretty important. Jumping to kind of your interface point, I think you also have kind of the issue that like the terms in the Commodities Exchange Act and the regulations are very focused on, again, to your point, like people acting or entities acting or a group of people acting. And that requires some central point to do that. And essentially most interfaces are being hosted by the company who has developed them. And there is kind of that central point. And so it kind of opens up this possibility that the laws can apply to a party who hosts that. But you also got to look at it and basically look at the specific regulatory regime and say, again, does it make sense in that context, right? If somebody creates an option protocol and then there's 20 different interfaces that allow access to it, I mean, and maybe the answer is yes. I mean, is every single one of them an FCM because they solicit orders? And then the question is, if you just create an interface, are you actually soliciting an order or not? And I think the answer, frankly, on that, on the FCM, is you would go back and you would look and you'd say, actually, they're not actually taking any property or money and holding it. And so they shouldn't be an FCM. It's actually the protocol doing that, which makes it a lot kind of trickier until you combine the two and it's the same company that created the protocol and the interface. And now you saying, do they have some level of control over the protocol that they could be viewed as holding margin or security for that on that option or that transaction. And so then you get into a situation where maybe it actually the law should apply to you and clearly maybe would apply to you in that situation. So
sorry, Colleen, just to key off of one thing that Marc said and to bring it back to Bitmex, the intent prong here when you think about these option protocols are pretty important. To the extent what you're creating in some way either should be registered or requires regulation under the Commodities Exchange Act. And this is not legal advice and this doesn't represent the views of our firm or anything like that, but you really need to consider what to do next and how to think about moving forward. And just to bring it back to the DeFi point, to think about the life cycle of your decentralization and how fast you can get there given what the regulations require.
Yeah, real quick, I'll just add, it kind of goes to the earlier point where you've got more clear guidelines with the BSA and where you've got criminal liability. And here, you're always going to hear facts and circumstances. And that's exactly what you just heard Jason and Marc going back and forth on. It all comes down to the facts and circumstances. The practical reality, though, is that there's enough flexibility in the CEA for our regulators to kind of they will determine what they think is right and they can kind of make it so. So they're going to look at the economic realities of the situation and kind of come to the law is malleable enough in the commodities world to kind of get to the conclusion they want to get to, whether it's the regulator or the judges interpreting those laws.
The one other thing I'll just jump in and mention is because Bitmex had kind of this international aspect to it, and there was purported attempts to geofence U.S. users. You saw both, I think, in the CFTC complaint as well as the indictment. You saw the view regulators have of VPNs and specifically their efficacy or lack thereof. I think one of them, I think it was the CFTC's complaint, specifically pointed out they knew that it was kind of a game in terms of somebody's going to turn on their VPN and use Bitmex's trading platform. And I think when you have an interface, it's a similar thing you should be thinking about. And they specifically talk about other options that are available. And I think that's something that projects need to think about.
Yeah, that's actually gets right to where I wanted to go next, which is, it strikes me that this discussion is very focused on U.S. law, right? But our audience is not just based in the U.S. DeFi is a very global phenomenon. And nonetheless, there is this sort of view that U.S. regulators are the world police. And the question becomes, is there a way to create a protocol or build something else in DeFi or be a DeFi user without being subject to U.S. jurisdiction? And in the DeFi world, we see a lot of different attempts of the interface providers to try to exclude U.S. citizens, right? There is geo-blocking. There's also sometimes you'll open up an application and you'll check a box that says that you're not a U.S. person or something like that. And I guess the question is, what can we take from the Bitmex cases, or what do we think in general, without giving legal advice, about the efficacy of these attempts to escape U.S. jurisdiction by blocking U.S. persons?
I would say two things. You need to show a sincere attempt, right? I think what you can really take from Bitmex is it wasn't sincere, right? They had this special thing where if you went on, they'd block you once, but if you tried it again, they'd undo it for you and things like that. So I think, you know, what we were all talking about before, being a truly good actor is important. I think showing a real thoughtfulness about how to use technology in a way that can potentially block US users, if that's what you're trying to do, is important. But the second thing I think we really need to talk about, because you know, I see a lot of this, and I know we probably all do, is this concept of structuring different entities outside of the United States to escape US jurisdiction. I think there are a lot of important lessons to take away from Bitmex, which are honestly just sort of what lawyers think of as plain vanilla, like jurisdictional questions, but just putting an entity offshore and saying that's your main entity, while still what's called like availing yourself of the privilege of doing business in the United States, is not going to escape, is not going to let you escape US jurisdiction. If you are purposely marketing to US users, if you have hired contractors in the United States, even if your entire you know, team is offshore, if you've done anything to truly come into the US in a purposeful way, you're going to be subject to US jurisdiction. That's just clear from the Bitmex complaint and indictment, and any sort of fancy structuring is not going to get you out of that.
I think the opposite is true too, a little bit, which is if you are truly like a foreign entity, you know, the way I think about it a lot of times with the US is like, if you're comfortable building a business that doesn't want the US as capital, that's fine. Don't take it, right? Like focus elsewhere on your company, right? And so if you are a foreign company and if you are attempting to block US people and you are taking kind of those sincere efforts to follow through on those and figure out where they might be, you know, failing and correct them, I tend to think that usually the consequences from the law, you know, are going to be less, right? I can't say the US is never going to extend jurisdiction in those cases or anything along those lines, but you know, I think where the issues, so I know probably there's a lot of international teams who are like worried, man, the US is going to be the world police. And my view is if you're taking kind of those efforts to block the US and you are comfortable not having those US customers, you know, it's not like the US is just constantly policing outside of the country. I think what you see more often is, yeah, people just want a simple technical solution to blocking the US, or they do want to set up in a way that allows them access to the US market, but, you know, with the benefits of not having to follow by the US laws. And that's where you're going to get yourself in a lot of trouble. Yeah.
One thing that's worth throwing in on the international point as well is, and Rebecca kind of touched on this, and we talk a lot of projects about this idea of like having several different entities doing different things in different places, even outside of the US. But let's just assume US jurisdiction for the applicable regulator. You know, what you saw in kind of Bitmex complaint is this idea of like, how are we going to treat them all as one? We're not just going to look at the one entity that is doing you know, that actually holds the software. Let's talk about kind of DeFi specifically, the one that actually like, you know, I guess technically holds the code. No, we're not just going to look there. If there's common ownership, common employees, common looking email addresses, you know, all of those things, financing coming from, you know, one to the other, that's probably something where the regulators are going to find a way to say, we're going to treat these all as one, and having put, you know, random entities in places with the hope of doing something useful in terms of mitigating your risk, I think is pretty low. And that's not talking at all about, you know, the impact that has on potentially limiting your liability from a contractual perspective between private parties. Maybe that's useful, but from a regulatory strategy, I think unless you're literally going to throw a foundation somewhere that has no common ownership, that is free to take all your money and run away with it, you know, that those commonalities are probably going to end up causing entities to be treated as one.
So we have about 10 minutes left. I wanna wrap up by getting a little bit more practical, and I want to start by actually putting Colleen on the spot here. There's sort of a view, I think, among some founders, and this is very much identified with the crypto ethos, that regulations don't matter, right? That crypto in general and DeFi in particular is illegal. And these smart contract protocols are just going to live on forever, no matter what the government says. So why should we even care about regulation? And Colleen, I'm curious for your thoughts, because I'm guessing that, in your work, when you're thinking about who you want to work with or invest in, probably regulatory compliance matters quite a bit, and showing a commitment to compliance is something that you take into account. So I'm just curious for your thoughts on why regulatory compliance in DeFi is important and not something we can ignore.
Yeah, I mean, I think it's important to acknowledge, I don't think any of us would be in this space if we didn't believe in the democratization of money and financial services, right? So to a certain extent, I think we understand that ethos. I mean, there's part of that we relate to, right? But that's just not the reality of the world we live in. CMT, while we are a proprietary trading firm, we've also been regulated all over the world. We're currently regulated by the SEC. We're regulated by the FCA right now. We've been regulated throughout Asia. And it's really important to us that participating in the crypto space, we're holding ourselves to the same standards that we do when we're regulated, clearly. And it's important to us to be engaging on platforms where participants have the same view. And that's why, again, like where the rules of the road may not be completely clear, I do think, what we've got internal checklists, right? So in DeFi, what type of platforms are we willing to participate on? And kind of the things that I ran through before are on our checklist, have the smart contracts been audited? How are they thinking about collateralization? So, I think these things are really critical. And it does also go back to that point of, where does DeFi want to go? Does it want to grow more than 200,000 users, wallets? Does it want to bring in, traditional finance? And there are just certain regulatory realities that come along with that. And I think the sooner the industry starts thinking about these things, the better. One, just in terms of, having, being able to legitimately show the regulators that the DeFi industry has thought through these things. There's good actors, there's good leaders in the space. Also with the hope that if and when, new rules are put in place, the regulators will look to adopt what the industry itself has done. So you'd rather have those rules and regulations informed by the people that know what's going on in the space than the regulators coming in and putting them on you. So I think there's plenty of practical reasons why you have to think about regulation in DeFi, in addition to just the pure legal reasons.
Yeah, for sure. And I'm sort of adding to that, I think there's also this idea that compliance doesn't matter because the regulators aren't paying attention yet, right? We're just now seeing this Bitmex enforcement action based on conduct from years ago. We saw the Kick order on the motion for summary judgment last week. Kick was an ICO that happened in 2017. We haven't seen enforcement actions really specific to DeFi, unless you want to call something like Ether Delta DeFi, which I'm not really sure that applies. I think I'm comfortable saying it doesn't. So, there also is sort of this idea that, well, maybe the regulators just aren't paying attention. And I'm sort of curious for everyone's thoughts about what happens next. Is DeFi flying under the radar, or are regulators paying attention and understanding what's going on?
I'll just say quickly, and then I'll let everybody else chime in. I mean, the regulators are absolutely paying attention. I've heard people say, well, the regulators aren't technical enough to figure out this space. I mean, they've been unraveling complicated financial transactions since inception. So DeFi is not beyond the intellect of our regulators. And what's going on is absolutely on their radar. So the other piece I should mention is that, similar to how it was like in 2013 when we got started, education was so important. We would call it our charity work in the space, like going to policymakers and regulators and educating about what is going on in this space. What is Bitcoin? How does it work? The DeFi industry is going to have to start their own efforts in that context and do their own charity work, where the leaders in the space come together and they go talk with the policymakers and the regulators, and they explain how these protocols work, and they show like how, you know, token incentives can be designed to protect the security of a platform, and just all the thought that the really good actors in the space have put into the projects that they're building. So that's as much as I'll say there.
I agree completely with both of Colleen's points, and don't have much to add other than I am sure the regulators are paying attention. They are in the process of educating themselves. And to Colleen's point, the people who are day-to-day working in DeFi and understand it, you know, at most really should be involved in ensuring that regulators are educated so that they can make, you know, good decisions.
Yeah, I'll just add like a couple points. So one, I think always enforcement lags, you know, a little bit behind the development of an industry. That should be expected, right? It takes a while for these enforcement cases to develop and the like. Obviously, we've seen with the history of this industry, that doesn't mean they're not coming, you know, that just might not mean they're not right now. But I think more importantly, and I struggle with this because I think there is kind of two minds about DeFi, right? There is a world of people who want a kind of truly unregulated financial system, you know, separate thing. And to me, I you know, I don't like, even if I don't espouse that view, I think there is, you know, some value in kind of making a political statement through, you know, what you're willing to do on that front. I guess the only caveat I would put on that is, fine, you can probably develop programs, participate in these ecosystems in a lot of ways that probably isn't, you know, touching on some of the same regulation. But if you want to build a business that raises millions from Silicon Valley people and you want to be, you know, rich based off this ecosystem, like that is where the law is going to go. It's going to focus on kind of where the capital gets concentrated, you know, and all of that. And it's hard to imagine any large financial system, right, not having some rules. And ultimately, I think that's a good thing. I think one of the other things that I struggle with, to your point, Colleen, obviously Jake and I work with the Blockchain Association. We try to spend time educating people and talking about this stuff. It's a very long and slow process. There's a lot of other great people who are participating in that. I think one of the frustrations that I come back to is like, I worry the rules of the road are gonna have to change a little bit, right? It's not just an education thing. It's also like, you know, we can see this in big tech right now, right? There's a lot of discussion, and there's, you know, a report out yesterday of like potential antitrust application to big tech companies. And there's a ton of criticism over like, does that even make sense? Do we need new antitrust rules? What is, you know, all of that. And I worry that without some kind of proactive action early on, we're going to kind of stick with the rules that we have. They're not going to fit right. We're going to get to a world where it's almost too big and it becomes almost a fight between two sides. And like, that's just something I don't want to see happen, right? With an industry that could be a pretty healthy and interesting industry. Like, I'm hoping there's effort on both sides to really think about what's unique here, because I think tech does present something unique to the finance industry, particularly in this little subculture that we're in.
Yeah. With just a few minutes left, I want to jump to my last question. I'm assuming we've either informed or terrified a bunch of people on this call who are working in DeFi. So, you know, the next question, of course, is what can market participants in DeFi, whether they're developers or users, what can they do to try to you know, make sure they are complying with regulations to mitigate the risk of being targeted in the way that Bitmex was? What is, you know, the next step for someone coming away from this feeling like they haven't spent as much time as perhaps they should have thinking about regulations? What should they do?
You know, I'll jump in real quick. And this isn't fun for anyone to hear, because it's challenging enough to be a founder, and then you've got sort of the expense with trying to figure out how to comply with US rules and regulations. But I think if there's one thing that's clear here, you're gonna operate in this area, you do have to have competent legal counsel. And that legal counsel needs to be not only substantively deep in all of the areas that we've just discussed, but also in the technology and how these networks work. It is just critical. And right now, there's just not that many of them. I mean, clearly, Rebecca and Marc are there, and they're phenomenal. We've worked with them in DeFi, and they're great. The other attorney we've worked with is Lewis Cohen at DLX Law, and he's also great. but you really have to be careful in choosing, you know, that counsel that they really understand what they're doing. So just add that.
I mean, the other thing I guess I'd say is like, take I guess a hard look at, like, there's always trade-offs between the regulatory compliance and business competitiveness, I guess you could put it in. And you need to have a willingness to make some of those trade-offs. You need to figure out where you're going to get kind of the biggest bang for your buck on a regulatory side that has the least impact on your business. And frankly, sometimes the answer is just, this doesn't work from a legal perspective, and so it doesn't work for you from a business perspective. But sometimes there are trade-offs that make a lot of sense, and you know, it's a hard decision to make, but you need to do that. And then I think the second part that kind of goes hand in hand with that is, to Jason's point, talking about technology again, is, you know, if you really want to get kind of furthest away from, you know, I have all these obligations, well, don't give yourself obligations. Don't be able to move, you know, $300 million from, you know, one wallet to another. You know, don't do those centralized things that you can do. And again, from a business perspective, it's hard. More centralized, it's easier to run faster, harder to bring a community together. Those are trade-offs, and I think, you know, one of the biggest ones is, it really comes down to, like, should these laws be applying to me? And that's not the answer necessarily. Like, sometimes the laws maybe shouldn't, but they do. But I think that's a core of it, is really looking at, should these apply? And most of the time, when you're doing things that a central party could do, the laws probably should apply and do apply to you. And so kind of think about how you can not be in that situation, or make necessary trade-offs to you know, reduce your risk.
Yeah, I mean, to Colleen and Marc's point, I think the other thing is, when you're a founder and you're building and you want to see what you're building really take off, things are moving very quickly. Marc and I work with startups not almost exclusively, but really all day, every day. And it's really fast moving. In this space, you have to slow yourself down just a little bit to be able to think about the things that Marc and Colleen and Jake and Jason have talked about, myself, on this call. Really is, how does regulation apply? At what point does it apply? To whom does it apply? And if you do have counsel that's facile with the tech and that understands DeFi and what's been going on over the last few years and what's going to come, the slowing down will help you ultimately build your protocol and build a business, if that's what you're doing, rather than really hindering you.
I agree with all of that. And I guess just to give my thoughts on this, not advice, but just my thoughts on how to approach this is, you have to think about compliance from the beginning of the design stage, right? The mistake that I think a lot of people make is they have some really cool idea of some financial primitive they think would be awesome. So they code the protocol and then they launch it, and then they hire legal counsel to advise them on whether they've done something wrong. That is not the correct approach, right? We are dealing with highly regulated financial services, and you have to think about compliance from the beginning of the process. And you have to develop a good faith argument why what you're doing is okay, or you need to just go comply with the regulations and get whatever license you need, or talk to whatever regulator you need to talk to, as opposed to closing your eyes and running forward and hoping that you don't trip in the process. Jason, you have one more thought to throw in there?
One slight variance on that, just because I get a lot of questions, which is, like, if you want to develop something, develop to your heart's extent, right? It's when you start to, like, want to make money off that thing, right? Like, I think there is a lot of protection to writing code, you know, even shipping out smart contracts. The problem is, if that smart contract, or if any of the activity on that sends money to you as a person, right? Like, that is where the regulations and all this stuff that we're talking about right now. So one of the things, you know, we'd have like hackathons internally, and people always worry, like, can I build this? I'm like, build whatever you want, you know, for the most part. It's, if this thing, when you launch it, or if you're planning to build a business, you know, on top of it, is going to inure to your benefit somehow financially, that's when, like, you know, if you've taken the time to learn Solidity, you're going to have to take the time to learn the law, you know, if you want to make money off something along those lines.
Yeah, I think I think to close it out, I would say for the most part is the key phrase there. I think it is not a magic bullet to say, well, I'm not making any money directly from this protocol, therefore everything is fine. So I don't want to leave anyone with that, that exact impression. Although, look, there are good faith arguments, and I think one thing we'll be working on is constitutional First Amendment arguments about protections for writing code. But I think that is, you know, just evidence that there is a lot to discuss here. I'm sure we could fill many hours of fascinating discussion, but we're a little bit over the hour now. So we'll call it a day for today. Thank you to Imran and everyone else at the DeFi Alliance for putting this together. I think this was a great discussion, hopefully helpful to the folks listening. Thank you to all of the great panelists, and we will pick this up again, I'm sure, in short order. Thanks very much.
Thanks, Jake.
Thanks, Jake.